believe Councilmember Branch will be joining us shortly. We are here to discuss the topic of citizen-initiated street closings again. We have discussed this recently, but revealed that some further discussion and policy work was needed. So I will hand it over to Assistant City Manager Michael Moore to kick us off.
Thank you very much. Today you're going to hear a presentation from Daniel King with the Transportation Department. Daniel will walk you through a little bit about the process and kind of where we stand with this today, a little bit in some detail. But before that, Brandon Poole with the City Attorney's Office, we've had some internal discussions around this, and I think Brandon has some useful framing around the intent of the state statute, the intent of the city policy, and then some of the standard or metric you might look at when we talk about what is in the public interest or not detrimental to. So I think he's got some helpful framing for you, and we'll start with that and then turn it back over to Daniel.
Thank you, Michael. Yeah, in talking with staff before this committee meeting and with council member discussions we've had in the past and with some discussions we've had at this topic at the table and at public hearings, I thought it would be helpful to clear up. Are you talking to your microphone? Sorry, clear. I didn't have Rand giving me instructions. So I want to clear up what I think could be some confusion about the street closure statute that Daniel's going to be presenting and what it's intended to do and what it doesn't cover. So the street closure statute, which is General Statute 168-299, it sets out the procedure that a municipality must follow once it's made a decision as a policy matter that it intends to close a street and it believes that closing the street is in the city's best interest. And the statute doesn't really kick in until that policy determination has already been made. And so the purpose of the statute is really intended to ensure that any property owners who rely on the street that's been proposed to be closed for access are, one, made aware of the fact the city is considering closing the street and intends to close the street, which is the first resolution that's passed is a statement of intent to close the street, and that they have an opportunity through the public hearing process to allow the council to hear their concerns about being cut off for access. The statute also provides that the standards where the council cannot close the street and that if it's detrimental to the public interest or it will deprive access to property owners along the corridor. So the particular requirements of the statute that you'll hear Daniel talk about are notice requirements, which requires published notice, mailed notice, and advertised notice. So clearly there's an intent to throw a very broad net of making sure that anyone who could be impacted by this learns of it before the hearing. There's a 30-day lead for the hearing, which is shorter than most of your public hearing requirements. So that also requires 4 weeks of public notice once each week during that period. And then you have the public hearing requirement, which is when someone who feels they'll be aggrieved by the closing can speak to the concerns. And so really, the standards are a check on the authority of a municipality that is looking to close a public street to make sure that those private property interests are protected and to prevent municipal action, whether innocently intended or not, from depriving them of rights of access to their property. And so what the statute does not do, the statute does not contemplate an application-based process for someone to request that a public street in general or adjacent to their property be closed for purposes of either dividing the property lines or just closing it for other reasons. The statute does not require the city to have such a process. And the statute does not speak to what standards the city can look into in trying to make that determination as a legislative matter that it's in the city's best interest to close a right-of-way. That's, for the most part, entirely outside of that statutory framework. So I just wanted to provide that context so as Daniel presents, it's heard within that context. I think hopefully that'll clear up some confusion that I think exists.
Thank you, Brandon. Again, I'm Daniel King with the Transportation Department, and we'll go through this. Much of this will be familiar to you as we've gone through it a couple of times before. I'll try to give a little additional detail on why certain requirements are there and how we've implemented them as we go through, and then obviously we'll have some time for questions after. So we'll start with the general statute, which, as Brandon mentioned, is 168-299. Talk a little bit about the city policy itself, the signature requirements, and what the review process looks like today. The general statute does start with a resolution of intent to close the right-of-way, so council would adopt that intention to close And then that requires the notification requirements that Brandon mentioned, which are certified mail, posting on the right-of-way, as well as the publishing for 4 consecutive weeks. The general statute does lay out some minimum findings, that the closure not be detrimental to the public interest or the property access rights of any individual. Again, there is no requirement or obligation to close a right-of-way. This would be based fully on the council's decision based on policy and meeting these minimum findings. Which leads us to our city policy. The current process sets up for petition applications to be submitted, the petition review, and then a presentation, including the resolution of intent to close the right-of-way. The public notification requirements then have to be met, and then the public hearing can be held. The submittal requirements for our petitions are the filing fee, providing a record map to Wake County for property identification, providing the description of the street, the reason for the closure, and then signatures of all of the property owners are currently required on our application. The signature requirements are only required from the statute if the property is not being divided down the middle. However, we do require those signatures to show support for the closure for all the property owners next door, as well as confirming that all those property owners have been notified. So it gives an additional way to make sure that people are aware so that they can come to the public hearing if they have concerns. So again, the general statute requires that a plat be recorded only if the division is not being made down the center line. It assumes that if it is being made down the center line, that it just vests to the adjacent properties. However, the city has a policy that requires a plat to be recorded in any scenario because there's property that's being added to their property from the perspective of record keeping, record search, and then in the absence of a deed, because there is no sale at this point, the map clarifies where the property lines are and provides that legal description. Our review process, the closure is reviewed for consistency with the general statute and the comprehensive plan, and then goes to a technical review with internal departments. That gives all departments an opportunity to determine if there are any easement needs that can be identified at that point. And then there's a recommendation for approval or denial based on meeting those requirements. The statute, again, requires that the closure not be contrary to public interest, and that it will not deprive any individual owning property of access. Again, that's setting a minimum standard from the statute, and our comprehensive policies give additional guidance. So those policies are before you here. We've gone through them a number of times. The most important here is that it's consistent with all of these policy of the city, but also that it's in the public interest and not just not contrary to. And staff always works under the assumption that our goal is to make sure that everything we do is in public interest. And so, again, this just outlines the difference between the statute and the comprehensive plan. The comprehensive plan, again, requires that we do it in the public interest, and the minimum standard set by the general statute is just that it is not contrary to. This is the petition presentation, public notification, and hearing process. We would prepare, submit consent agenda item with the resolution of intent to close, with a request to set the hearing. Then this would be advertised, the notifications would be sent, and then there would be a hearing where staff would present the overview. There would be an opportunity for both the applicant and anyone who had concerns to speak. And then if approved, the applicant would submit a plat for review and recordation. And I'm happy to take any questions that you may have.
Questions for staff?
One quick one clarifying. Can we go back to the last slide?
Sure.
This whole process of staff preparing and submitting the consent, that's after all the signatures have been made? You wouldn't even start that process until you got...
That's right. Until we had a full application for us to process, we would not start that process. So the general statute, as Brandon mentioned, kicks in at the point that we've reached the decision to move a process forward because it met all of the standards.
Right. So if it has been signed off by all property owners, then hopefully this is an easy hearing. That's just a open closed book. But if they signed it, they probably wouldn't sign up in opposition in that public hearing. That's the intent, right?
That's the intent.
Perfect.
Yes.
Okay. Cool.
And,
Thank you.
that's why we require those signatures.
Perfect. Thank you so much.
Anything? Okay. Are there any members of the public who wish to speak? How about 5 minutes, Bryce?
Good afternoon, members of the committee. My name is Chad Essick, attorney with Porter Sproul, 301 Fayetteville Street, Suite 1900. I'm here this afternoon on behalf of Ryan and Sarah Reed, who you may recall submitted a street closing petition last year that was ultimately denied. I'm also here because I have some interest in this topic, having represented the development community and having done street closings in other jurisdictions as well as the city of Raleigh. And so just from a policy standpoint, I think your city, Brandon, did a nice job of talking about kind of the state statute and the standards that are set forth in there, as well as kind of what the city decides it's going to be its policy if they're going to go above and beyond what the state law requires. And I'll let Brandon advise you on whether or not that is appropriate or not. From a policy standpoint, I will just make the comment about requiring signatures on of everyone to sign the petition. I would note that that's not required under state law, and obviously, as was noted, you don't have to have all the signatures on the plat if you're dividing it down 50-50 at the middle line. By having the policy of requiring all the signatures, you create a situation, I think, where, let's say you have a street where 6 properties abut it and 5 people want to close it, and one person, either you can't find them or you can't get them to sign the petition, or it's an heir property or whatever the situation is. If you created a situation where those folks can't close that street because not everyone has signed the petition. I understand the idea behind it, but I think what I would suggest is that the city council would have the opportunity at the public hearing process, if someone was opposed to it or had legitimate reasons to be opposed to it, to express those concerns, right? And to have the city council hear them and make a legislative decision about whether or not it still made sense to close that public street because it wasn't detrimental or there was no access being cut off to those folks. So I would just pose that situation. Also, I guess, and I'll let Brandon advise you on the issue of, what if the city of Raleigh wants to close a street that no longer serves any purpose? Does it require all the property owners to sign that petition under that scenario, or how would that be handled? So I think there's ways to accomplish the concerns about making sure folks are aware of it, they have notice of it, they can come and speak their mind about whether or not they're for or against it without a policy that goes above and beyond and requires everyone to sign it. So I wanted to make that point for the committee's consideration. I don't know, there wasn't discussion about the compensation issue that came up at the last meeting and how that was calculated and determined and where that's done in other places. I don't know if that's going to be a discussion for today or not, but it's certainly something that I think warrants a discussion, and perhaps myself and perhaps others, my clients and perhaps others in the development community might be interested in that topic. I think the whether or not what standards you decide you want to apply. Again, the statutes standard for the, I guess, as the city refers to as a minimum standard, is that you're looking at, is it detrimental to the public? Is closing the street going to prevent emergency access? Is it going to prevent some street connectivity, pedestrian connectivity, all those things? And secondly, does it prevent someone from having access to their property? If the city says we want to go above and beyond that and say, is it in the best interest of the city? I think that's a policy decision that you guys can evaluate what standards you want to apply. I would note that I think the idea of closing a street is where that's no longer needed or no longer used or no longer connecting to anything, is that it reduces the city's liability, it reduces maintenance cost, it then puts that property back on the private tax rolls for purposes of taxation. So I think there's a lot of interests that come along with closing a street that's a stub or whatever the case may be that's no longer serving a purpose, without the need for it being in the best interest. I think there could be I think there's a reason for doing that. I'm happy to answer your questions. I don't know if Ryan or Sarah want to say anything as well about their experience and things that they would like to see as it relates to as you consider what policy you want to adopt. But I'm happy to answer any questions or be a resource to the committee as you go through this process.
Oh, please, I'll ask my questions after you guys are done, please.
Definitely don't need 5 minutes. First off, thanks again for taking time to put this on the agenda. You've probably seen my face more than you wanted, and I've learned more about processes than I probably wanted. I know you guys make decisions on a lot of really important things that are way, more impactful to the city than this. And while this impacts some of us and like our family cares about it a lot, it's small in what you do overall. So thanks for that. Having been through the process recently, I kind of had 3 quick process observations that aren't necessarily legal in nature. First, the process shown on the city website shows that staff is already evaluating should the street remain open for general circulation and if anyone is deprived of access, but those results aren't shared with the petitioner ahead of time or with any opposition ahead of time, nor was it shared at the public hearing to council of what their results and their determination of the public interest or of the, was anybody deprived. I think it would help if council could potentially share those, or if staff could share those findings as part of their presentation at the start of a public hearing, so you know what their determination was. Second, in our case, new technical objections from the opposing property owner came up for the first time at the hearing, and nobody had really heard them before. There wasn't time for staff or council to verify those. A small improvement would be to allow those objections to be vetted either before the hearing or through a defined follow-up process after the hearing to make sure that they're vetted and appropriate. Finally, it'd be helpful if staff clarified what a closure does and doesn't require of abutting property owners. For example, in our case, I think the neighbors raised some good points, like would we still be able to park on this if it's closed and becomes private property? And uncertainty about whether they continue parking on portion of the street that would become their private property. If they could clarify kind of post-closure, do you have to do anything? Do you have to spend money to improve or can continue to use it as is would be super beneficial to help, eliminate opposition that is just because of the unknown of what might happen. I think steps like that could help make clearer and more informed decisions and potentially save time in the hearings and everything else. Thank you.
This might be for staff, just to clarify again, when we're talking about it, if it's 50-50, then there isn't an issue. The only time this comes into play is when we don't want to do the 50-50, when we want to take more of the, or a resident or something. Did I hear that correctly?
So that would be related to the plat requirements.
Oh, okay.
As far as the decision whether to close or not, that would still be a policy decision that the council would make based on the information that's presented.
No matter if it's 50-50 or if it's, got it.
Correct.
Okay, thank you for the clarification.
But to drill on that a little bit further, so if we imagine a hypothetical scenario where we allowed an application to proceed without, we said we're going to split it 50-50, so we don't need signatures of both property owners, that would meet the state standard, but it wouldn't meet the city's standard for the city maps. And so if we flash forward to some future scenario where one of those property owners sells their house, are we opening ourselves up to any potential risk of disagreement on where the property line is?
Yeah, I believe the distinction that Daniel was trying to draw was the state statute requires a plat to be signed by all owners if the statutory presumption of drawing a line down the center of the street and dividing it half on one side, half on the other isn't followed. The city process is where that plat requirement for those 50-50 ones comes into play. And I would defer to Daniel on specifics, but I think the intent for the city behind that, particularly in a growing urban area, is that for future title research, future determination of setbacks, common understanding of where the property line is, having a recorded map that depicts that, particularly with owner signatures, is going to be easier as a matter of record than if the order is recorded at the Register of Deeds and someone 30 years from now needs to find that in a title search. So I think that's the policy objective, but I do think you touched on the point that if the city policy requirement of requiring all of the adjacent owners to sign the application is waived, there needs to be consideration of waiving that at the plat stage as well, simply because you're going to create a situation where someone could sign the application and then simply refuse to sign the plat, thwarting the whole process.
I have a few follow-up questions. Something that Mr. Essick brought up in his comments are we're requiring 100% participation of the affected property owners, the signatures. But I think it's very different when you have someone who's opposed versus someone you just can't not locate. So how do we treat situations where there's just a missing property owner, if it's an heirs property or an out-of-town investor? I mean, that is a little different than someone just saying, I'm opposed to this closing versus we just cannot contact you. Is there a way to carve out those separately is a question. And then I'm also, I guess, I know it's a little different because of the plats and recording of deeds, but when we had our sidewalk petition program, we had a threshold requirement. So it wasn't 100%, it was a number of responses. And we would assess folks for sidewalks even if they voted no on the ballot or didn't respond. And so is there not a way to carve out a distinction here for a threshold instead of 100% participation similar to the other programs we have?
So I can speak to it from a legal perspective. I would defer to transportation staff and Michael on the policy side. I think from a legal perspective, the city could certainly come up with thresholds where it was more than just one property owner. It could be a certain percentage. I know a number of other jurisdictions have those type of threshold requirements as part of their process. Wilmington in particular, we looked at, has different formulas for if you only have 2 impacted property owners versus if you have many, and amount of how much, again, it might be based on frontage, or if it's the number of owners, there's a percentage that you have to be able to show the support of for the application to start going through their process. So from a legal perspective, that's something that can be done. I don't know how we would distinguish between the owner who can't be found versus the owner who is not supportive. I suppose an affidavit process for the applicant could accomplish that. And I think the policy question there for the council would be at sort of the entry point to the process where the council is making the determination of, are we comfortable stating our intent to close the street? Is the council comfortable making that decision using Mr. Essick's example where you had 6 property owners but only 5 could be located? Is the council comfortable moving forward to close the street if they can't get certainty that that 6th owner isn't going to be cut off? Now, staff in their evaluation will also make a determination about, can that 6th owner have access to the property without the street being, with the street closed. And I think that's where the restrictions and the general statute will kick in. And if council can't make the finding, if there's a clearly landlocked parcel and that owner just can't be contacted, I think the statute would direct that the council can't make that finding and could not adopt the closure. And there's not a corresponding, if the council can make the finding, it must close it. It's discretionary at the council's decision.
I have a follow-up. How many of these issues have we had? Because we have this as an agenda item now, but how often is this happening?
Very, very infrequently. So we do not see these very often. In fact, I'm thinking, Daniel, maybe you can correct me, you may recall we had one up off of Dartmouth.
Yeah.
And this one, and it may be the only 2 that we've had.
So they're certainly the only 2 we've had recently. There have been other ones in the past, although very infrequent, that the applicant could not get all signatures. and those did not move forward. And so that was the past practice, that they just did not move forward. In these cases, both applicants approached the council to request that they move forward anyway, and so that's how we got to this point. But these are the only two that have come up in recent history.
I mean, I have some general thoughts whenever we're ready for that.
Yeah, I think I was going to ask the question about the frequency too. And so just to kind of set the stage as we come back to the table for discussion. So we don't have to have a street closure process at all. We do have one to meet a higher standard. We then do not further have to have an exception process that says if you can't meet the administrative standard, you can still find your way to the city council. And so we don't have to have that process at all, but we've now created it. It sounds like we may have created it for two applicants in all of recent memory, so we may want to ask ourselves if the juice is worth the squeeze on having a full exception process. I think we would want to consider if we allow an exception process to continue, we will continue. The things we will get through that exception process will be messy and will be putting us in positions to opine on neighbor on neighbor concerns or other sort of messy, asking us to make messy determinations about whether people get free property that they didn't want and their property taxes increase or this or that. And so I think the policy question we might ask ourselves is like, is this exception process useful? and if we decide to keep it, then we're really signing ourselves up and future councils up for seeing these messy cases. Understanding that most of them, by and large, the ones come through that aren't messy, all the properties are owned by the same person and they're just, rejumbling the properties, closing a little corner so they can put in a different street that's better serves on our policy objectives or whatever. So, anyway, that's just kind of how I would frame the conversation, but pull it back to the table for discussion.
Yeah, I mean, I have a few thoughts. I think we should be making policy to address overarching issues, and it sounds like this is not an overarching issue. We had just two randomly pop up at the same time. One was withdrawn, and we're with this one. I'm going to use this opportunity to vent my frustrations and concerns with the case that we had for public hearing, and I don't mean any disrespect to anyone involved in that case, but it was frustrating to me to hear the opposition say that they would be deprived of ingress and egress to their property. They live on a main road, and that road was not closing. They purchased a home without a driveway, and they would still have a home without a driveway. In fact, if their street was closed, they would have had a driveway. And so this argument that I have no ingress or egress, to me, does not meet that standard at all. Their property is not floating in an island surrounded by other properties with no ways for them to get in and out. I think the reason why there's a present dispute is these folks are parking their cars and using their basketball hoops on public right-of-way right now. So they're not interested in signing a street closing petition because they can have their cake and they can eat it too. So regardless of what happens, I don't think we need a policy on this. I would like code enforcement to go out and make sure that folks aren't using publicly owned land for private purposes. And if they would like to use publicly owned land for private purposes, then they should join in the street closure petition and come to the table with a solution. One immediate takeaway I'd like from this hearing is if we could please get code enforcement out to the folks that are parking in the public land now and give them notices of violation, because I think that has precipitated a large part of this issue.
I completely agree with everything you said. I think that this is too small to make an overarching policy determination on, but I would love for code enforcement to head out there. So completely agree.
I've made a note to make that contact.
All right, so it sounds like there's some agreement here that the portion where we recently opined that we needed this exception process, we are now realizing perhaps we overdid it, and we would like to put the genie back in the bottle related to not having an exception process. Moving forward, when citizens come forward to close the street, they'll need to have complete applications. That can be related to all property owner signatures. I think the other case that was eventually withdrawn was related to the sort of proving that there's equal public benefit as compared to private benefit. And so we did have some discussion around whether the menu of options for what counts as a public benefit, whether that was like sufficient and modern. Do we need any advice from our legal counsel regarding that menu? And
Sure, that's certainly something that we can provide. I think sort of the earlier reframing, the decision point to initiate the street closure process all happens outside of the street closure process. And so that really starts following into the council's general legislative discretion on policy matters. And so while city staff have their technical process of how they evaluate the applications and then bring them up to the council for consideration, it's really a much broader legal standard as to what factors the council can take into account in considering whether or not to pursue a public street closure and to initiate that process. And that's something we can certainly work on guidance and have discussions with you all about.
okay,
I move to refer the item out with no recommended action.
we do need recommended action to undo the.
If you would prefer us to dial this policy back, we would request some direction on that.
I move for you to dial the policy back and send code enforcement out to the property that's parking all their cars in the public right of way that sort of precipitates the problem.
So noted.
That's sufficient? All right, second. All in favor?
Aye.
All right. So you have everything you need, staff? All right, meeting adjourned. Thank you all.